Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Group of Downing Fry, and today we're joined with our host Jim York and his guest Donald Ross Jr., President and CEO of Ross Title and Escrow.
Thank you, Morgan, for the introduction. Well, thank you, Don, for coming on the show today. For the viewers that haven't seen or heard of you, who are you?
Darned if I know. I'm Don Ross. I'm a local real estate attorney. I have a degree in taxation. I'm the attorney for Downing Fry Realty, one of the owners. My family's been in this area since 1973. My whole family's been in real estate and construction. God help me, two of my kids are lawyers and my cousins are lawyers, and they all do real estate or litigation. We have Ross Title, we have a law firm. I work with my son Christian, and we do quite a few closings. Our closers have been with us for decades. Most of them are actually related, so it's a really nice synergistic group. They work well together. Good at returning phone calls. People seem to be happy.
Yeah, I know our clients are, which we've been using you for a long time.
But, appreciate it very
Don,
much.
you know, we have real estate contracts that we discuss every month on the show, different parts of the contracts and, you know, different types of contracts. But I don't think we've ever discussed in the last, 8 or 10 years we've been doing the show, addendums. And there's a lot of addendums that go to contracts. And I'd like,
There are?
Yeah, which, you know, we got a bunch of them here, just a few. And
Sure.
I wanted you to just touch base for our viewers about some of them because we only have a certain amount of time we can do the show here. So why don't you just give us your input, like what we were talking before the show started?
Well, I mean, there's quite a few of them all together. I mean, Nabor has about 25 or so. Farbar has another 25. Before I came here for the show, I asked some of my closers, which ones do you see, actually see in use?
Right.
And really, there's only a handful that we actually see.
That's true.
A lot of folks have enough difficulty getting to fully comprehend the 12-page Naples Board of Realtors general contract. So when you start attaching an addendum or addenda to the contract, it's a fine line between, what's the goal of the client? Does this form actually achieve it? Is there another part of the existing 12-page contract that already covers it? Or is it covered in another way because it's a condo and you have the condominium review period? Or you have an itsy-bitsy little deposit and the buyer doesn't have to really worry about losing much. So do you want to scare the seller off by having 14 addenda attached to the contract? For me, it's always a balancing test between, I have to find out why they want these things first.
True.
What are they worried about? And is there another less intrusive way of achieving the same goal? Something that's not going to raise the concern of, say, the current owner, if you're a buyer.
That's true.
Because if the current owner gets excited or nervous, it's a Saturday, you're showing something on a Saturday, they're going to want their lawyer to look at it. And if their lawyer looks at it, it's always harder. It's always harder. And then they're going to start picking it apart, and we want more of this and more of that. So, is it necessary is the first level of analysis. Is it going to cause the other party to go running to a lawyer? And, some lawyers are deal killers, some aren't. It just depends on how conversant they are in real estate law.
That's right.
A good real estate lawyer is not going to kill the deal, but if they're a litigator, you have problems. And if I can find another way to assure the client, you're safe because the second deposit is like in 16 days and you're only putting down $5,000 now, and are you worried about the 5?
Right.
You want your offer accepted.
That's right.
So you got to zoom in first and say, what's the goal? And then zoom back and say, is this going to jeopardize the acceptance of your offer and the ultimate successful closing itself?
Especially
You-
in today's market,
Yeah,
right? When there's
it's a
multiple
seller's market.
offers,
I mean,
right.
I spent a good 45 minutes this morning on the phone with a Boston lawyer, and he was excited about, he's buying a condominium. There's pending litigation that nobody told him about. They're suing the insurance company to get reimbursed for impact glass for the sliders. And there's a potential special assessment that nobody told him about. And being a good Boston lawyer, and I'm from Boston, as I guess I didn't mention earlier, you know, we tend to get a little aggressive when somebody tries to get too clever, you know, with us. Just tell us what it is, and we'll either say yes or no. So we, you know, you don't want that. You know, you really don't want that. So we have a lot of these forms, and some of these I really love. I mean,
Which ones do you don't love?
well, the ones I don't love, I'll start with the seller's disclosure, actually, because it's not 99% of the form is just lovely,
Right.
and I'm a big fan of disclosing. I just don't like right above the buyer's signature the language that indicates that if the buyer signs this seller's disclosure, that these items disclosed on the seller's disclosure are not a defective item under paragraph D2B of the general contract. So the seller can disclose they have a leaky roof, or they have mold,
Right.
buyer signs, it's not a defect. Now, I mean, technically under the contract, they can't say, they can't put that in their buyer's election form and say, seller, please fix it.
Right.
But what in the real world happens is, I'm not putting my second deposit down, or maybe the first deposit is 3 days after the effective date,
Right.
and they won't put that down at all. And in that case, the seller can't do anything. But a lot of times I'll get people and they've already got their money down,
Right.
and it's too late. So I don't like the fact that they put that extra pitfall in the
Right.
form. You know, the form's supposed to be instructive.
Right.
You're disclosing something. Let's not have an election by signing, we're electing that this is not a problem.
Exactly.
You know, keep it pure, in other words. So, you know, that form, you know, I don't really care for that much, that part of it. I like the Farbar one better because it just discloses. There's no repercussions beyond disclosing it, which is cleaner. The appraisal contingency, you know, I'll get that, and it confuses sellers, and in this market, I mean, this appraisals are all over the place.
Right.
You know, what's the last sale in your community here? Is that a true indication of what it's going to be by the time you close, in 6 months or next year? I mean, how exact are these appraisals?
Right. It's an art, right?
It's an art, which is a polite word for saying it's not exact. It's not.
Right.
It's an estimation. It's an educated estimation, but you know, it's not spot on. So you know, that one, the pre-closing occupancy, I really don't. I rarely have a situation where I would recommend that to anybody other than the storage of furniture. And I have to mark up the form, and only lawyers are supposed to do that, lawyers or the client.
Right.
And I'll mark the form up and so that it's just for the storage of the furniture, and the actual buyer can't move in, you know, until closing, because we've had situations where the person didn't get their financing, or there was a title defect and it wasn't cured, and the buyer won't get out.
Well, what happens if you, because we've done that before, what happens if they waive their deposits, you know, have substantial deposit, and they're in between homes and they need to get in, or whatever the case might be? I mean, then is that a better situation? Yes?
That's better, but the last time I had that happen, it was how much was it? It was probably like $120,000 deposit, and the buyer was a Canadian couple, and I think they were going through a divorce, and there's no way the money was frozen by the Canadian courts, and they couldn't go forward with the closing. So they tried to get out of the deal by having a really extensive inspection report and making an exhausting buyer's election. And we want the seller to fix all these things. And I spent probably a good not 3 full days, but I met with the realtor in question for the buyer 3-4 days in a row, and I have a special letter I use indicating, well, we're fixing these things even though they're not defective items under the contract.
Right.
Trying to, my audience is the judge, because I'm going to go after the $120,000.
Right, yeah.
So I'm kind of writing this as though the judge is reading it and trying to decide who gets the $120,000. So you start out by showing how wonderful you are by agreeing to fix all these things that aren't defects under the contract, and then you'll point out, well, we're not going to fix these other more expensive things because under paragraph D2B, whatever it is, penicillin aspergillus is not a defective item, for example. And then we end up with, I have this sort of catch-all paragraph that if the seller identifies something that is not, that is a defect as defined in the contract, then they can identify the point in the contract where you agree to fix that too.
Right.
So it's sort of the catch, still, just in case I made a mistake and missed something, or the inspector made a mistake and missed something, again, I'm thinking of the judge. I want the judge to say, gee, what nice people. They're fixing all these things they don't have to. And they're not expensive, but it still looks good for the judge. And they fixed everything that was technically defective. And then they also agreed that, hey, if we missed anything, we'll fix that too.
Right.
So in that particular case, for the $120,000, we got the whole 120, and the realtor got about 40 of it. I mean, the realtor's entitled to the greater of what is, or the lesser of his commission, what his commission would have been, or half the deposit.
Right.
So, this particular realtor, is a good
Right.
customer of mine, sends me a lot of business. I spent the 3-4 days it took to help him get his money and help my client get their money.
Okay, then I guess, how about leasebacks?
Don't care, well, almost never see them. I know FARBAR does it. What we use is the pre-occupancy or the post-occupancy addendum. The difference between those three is this leaseback, when you go to it, and we're skipping around here, has the contingency in it that if they don't agree to an acceptable form, the parties may terminate, the buyer might terminate, and you don't want the deal to fall apart over a 20-page lease. Some people over-lawyer the deal by having too comprehensive a lease that scares the living daylights out of the other side. So, in Collier County, we're a bit more, dare I say, civilized. So that usually, if you're going to allow the seller to stay after the closing, I recommend the addendum to sales contract post-closing occupancy, which is actually an excellent form. And I like that form quite a bit. The leaseback, the technical legal advantage, if you can get past those possible terminations, is that you're eligible for the expedited hearing before the judge if you have to evict somebody. But we don't run into that too much. You just put in a big enough penalty in the post-closing occupancy addendum that there's an economic incentive for the seller to get out.
How about, what do you have next then? If I change the order, how about escalation clauses?
Escalation clauses are great. I mean, they're a function of what we're going through with COVID. I mean, we have, in a seller's market, escalation clauses are lovely. A lot of people, because there's been so many versions floating around town before NABOR came out with their official form, don't understand them. In practice, the way they tend to work is the client receives an offer with an escalation clause. It shows the maximum the buyer is willing to go up to in their price, and the seller immediately wants that maximum. Because if you don't get that maximum, you're going to feel like you left money on the table. I could have gotten that. Gee whiz, that's how far.
So why don't does an agent just go in with the max?
Well, I tell the agents, just pick up the phone, call the selling agent, and say, make me a clean offer with no escalation addendum. After you've evaluated all the other contracts or offers with escalation addenda, call the one you like the best, the one that you think is actually going to close, and maybe they have kids and you want kids to live in the house and so forth. and tell them to make a clean offer with a nice deposit accompanying the offer
Right.
with no escalation addendum
Right.
at all. So it's a good first step of a two-step process.
Exactly. That's how I feel about
But
it too.
you're tipping your hand on how
Right.
high you're willing to go. So the
Exactly.
seller wants that.
Yeah. Yep.
I say, go for that.
Go for that,
I always say, go for that, sure.
What do you got next there?
You had the appraisal contingency.
Mm-hmm.
And actually, I was asked by another attorney this morning, is that even necessary? And I said, well, it depends upon are you getting a mortgage or not. I mean, in this market, you can't go in with an appraisal contingency.
No, you
There's
can't.
no way in God's
No.
green earth is the seller going to accept it. It gives the buyer the right to terminate the contract. The seller
Is not
it
good.
rules the world
Right.
these days. So, this is not usable now, but,
Right.
in a
But-
different market where it's a buyer's market,
Right.
you can get away with it.
That's right.
The ones I
Things could change in Edith.
things could change. They have an addendum for, this includes tangible personal property. You have to list your addenda on page 11 of the NABOR contract. If the buyer's going to go get a mortgage, the bank's going to have some concern about the furnishings and
Furniture.
how much they're worth. So I never see that.
Right.
If you're going to include furniture, we use a tangible personal property agreement, and,
Right.
and everybody has their own. I have one on my phone, and I just send it to you or
Right.
whoever I'm working with and say, use this, put all the furniture on this, and be clear
Right.
when you're describing it. The FERPTA addendum is a good one.
It is.
It prompts a conversation because people get confused about, what does it stand for? Is that a tax upon a tax? Gee whiz, I'm selling it for what I paid for it. Or that's more than what my tax would be. And, if you're the buyer, and I get this at least once a week, do I need to sign this, Don? And I said, if it's necessary to get your offer accepted,
Right.
and you're actually going to occupy the property or intend to occupy the property over half the time it's used for the next 2 12-month periods, then yeah, you should sign it. If it's necessary to get the deal accepted and you're not renting it out for the next 24 months, yeah, you got to sign it. If you've already got an accepted contract and the listing agent comes to you and says, sign this, I always ask, how has the seller treated you so far? Have you made your request for repairs yet?
Right.
Did they refuse to replace that light bulb?
Right.
Were they obnoxious? Were they difficult? Were they nice?
Exactly. Right.
One good deed deserves another.
Another good deed, right.
And I know it's the inverse of the golden rule, but it's pretty tough to be, doing a favor for somebody after they've been incredibly nasty to you. So I said that's a bargaining chip. That has value to the seller. They don't have to. If it's under $300,000, they don't have to withhold anything. If it's over $300,000, under $1 million, they withhold 5% less. So it's a financial benefit.
Exactly.
So just make sure that you get something.
Right. Exactly.
It might just make the deal go smoother. They
Right.
might let you move in early. They put your furniture in the garage, something.
Right. Something.
Yeah, so it's a useful tool, and it starts that whole dialogue with the seller. What the seller's supposed to do, because Canada or the UK, they generally looked it up on the internet, but they're all confused. So being a tax lawyer helps. Thank goodness.
Definitely does. I think we've covered just about everything, right? Or not?
We covered quite a bit. There's a survey addendum. Oh, one I get all the time is difference between an amendment and an addendum.
Right.
An amendment is a change.
Right.
You're changing the price, you're changing the closing date, you're changing who's buying. It's a change. An addendum is something you add to it.
Right.
Now, if you're before a judge, does it matter? Probably not. The judge is going to look at the substance of the agreement and not what you call it. They give weight to the substance of the agreement, not the form of the agreement.
Right.
You can call it whatever you want, but what specifically is said in that document.
Right.
The forms that give me probably a lot of apprehension, we have blank amendment forms, blank addenda forms, and agents or buyers or sellers will write their own contingency in there.
Right.
And that just makes, I mean, it's nice to have a form, but one, Jim York is not supposed to be practicing law.
Right.
Two, they're generally not precise with the language, so there's a lot of wiggle room for us lawyers to wreak havoc. You know, they'll use words like may or wants, or you know, or they don't identify the specific time periods. Or, and I think we talked about this in a prior show, if the deal is subject to like a new roof, or the buyer making certain repairs by a certain date, it almost never says what happens if they don't.
Right.
And you know, if you just run it by me or whatever lawyer the realtor is working with, they're going to plug in the missing spots. You know, you'll get a 10-day extension, or you'll get a credit for the estimated cost to do the work, or the buyer will have 5 days after that time period to cancel the contract and get their money back. Whatever it is, but you need that step too.
Right.
And you want to make sure you use affirmative language, not what we call wishful or precatory language.
Right.
You know, I want to win, the buyer wants new windows in the living room. Well, I want to win the lottery,
That's
but
right,
it'd be nice if I bought a ticket one of these days. But so, we just tighten it up and fill in part two if whatever doesn't happen. So I think that pretty much covered it, Jim.
Well, I think we did a great job. You did on explaining as much as we could in the time period we have, and I hope it's beneficial to our viewers. And thanks for coming on. And
thanks for having me.
I'll see you next month at St. Patrick's
Same
Day.
time, same channel.
Yeah, same channel.
Do I have to dress as a leprechaun, or?
Thank you for tuning in today, and we'll see you next week. Thank you.
Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.